I'm going to let everybody in right now.
All right, I think we're ready to begin. Good afternoon, everyone. I'm delighted that you're all joining us here today. I know this is a combination of my federal Indian law class and then also people joining us from throughout the law school and throughout the country. So I want to just start by sharing my screen and giving a few introductory remarks regarding what we're going to talk about today, and introduce myself and then introduce our esteemed panelists. So let me start by sharing my screen. Hopefully you can all see that. Is that good? Great, thank you. Okay. As always, there's the slight navigation issues with Zoom. So, all right. Well, let me just begin. My name is Angela Riley. I am a professor of law and director of Native Nations Law and Policy Center here at UCLA School of Law. I'm a member of the Citizen Potawatomi Nation from Oklahoma, and I'm delighted to have this incredible group of speakers here today. Stacy Leeds, who is a judge at the Muscogee Nation District Court, is not going to be joining us because she's one of many people who are experiencing power outages in Oklahoma with one of the most unprecedented storm systems Oklahoma has ever seen. So Judge Leeds sends her regrets. But I am delighted to have our other speakers here who I'll introduce in just a moment. As you know, what we're here to discuss, the topic of our discussion today is McGirt versus Oklahoma, reflections on a landmark case and what we've learned so far. And this is part of a speaker series that we're hosting at Native Nations Law and Policy Center at UCLA in the spring semester. And we're converging this with my Indian law class as we're in the process of studying the definition of what is Indian country under federal law. So I'm just really pleased to be able to have this discussion today. You can see here on the slide that I've presented to you on the far end of the Trail of Tears was a promise. And those of you who are familiar with the McGirt decision know that this is the first line written by Justice Gorsuch in this landmark opinion that came down in June of 2020. So what our goal is today is to talk about the case and to, in a very concrete way, talk about its impact on the ground. And in order to do that, I'm delighted to introduce our speakers. I should also say that I am here in Los Angeles and I'm on the unceded land of the Tongva peoples. So today we have with us, let me just do the introductions. Jonodev Chaudhuri, who is the ambassador for the Muscogee Creek Nation, a lawyer, and has a long career in the field of Indian law. And he wrote a piece for the Harvard Law Review Forum that my students have read. And if you haven't read it and you're out there, I highly recommend it. His own personal connection to his tribe, to the removal of his people to what is now the state of Oklahoma, and his connection to this case. So I'm delighted to introduce Ambassador Chaudhuri. And then also we have Sara Hill, who is the Attorney General of the Cherokee Nation and a Cherokee Nation citizen, who's an incredible lawyer who is really doing so much of this work on the ground as we speak, and really working her way through leading the Cherokee Nation in its application or potential application of McGirt and its principles. So I am delighted to have you both here. Let me just say a couple of words about the case for those of you who may not be familiar with it, and I'll just give a very brief introduction. The case is McGirt versus Oklahoma. It was decided, as I mentioned, in June of 2020. And the basic facts was a man by the name of Jim C. McGirt, who was a enrolled citizen of the Seminole Nation, was convicted in Oklahoma State Court of several very serious criminal offenses. In his post-conviction proceedings, he claimed that Oklahoma didn't have criminal jurisdiction over him because he was an Indian and committed his crimes in Indian country. So he was arguing that the jurisdiction should have been tribal and federal under the Major Crimes Act because he actually committed the crimes within the boundaries of the Muscogee Creek Reservation. The state of Oklahoma for many, many years, if not probably well over a century, had claimed that the Muscogee Creek Reservation no longer existed and that the state of Oklahoma had jurisdiction there. So the question for the court was whether Congress had ever abrogated the treaty that set up the reservation boundaries of the Muscogee Creek Nation. And if Congress had not done so, then the reservation had never been disestablished or diminished, and its reservation boundaries were still intact. And in writing the opinion, Justice Gorsuch wrote for the majority that in fact the boundaries of the reservation had remained intact and Jim C. McGirt had committed his crimes within Indian country. So what seems like a pretty straightforward application of a treaty interpretation is really one of the most revolutionary cases in the field for many, many years because of its implications for jurisdiction on the ground in eastern Oklahoma, and not just for the Muscogee Creek Nation, but potentially for 4 of the 5 tribes who have similar treaties and similar relationships to the United States. So this has far-reaching impacts in Oklahoma and potentially around the country. So I'm delighted to have our panelists here today to talk to us about what's been going on and share their perspective of what's happening. So I will now mute myself and turn it over to Ambassador Chaudhuri to lead us off.
And thank you so much, Professor Riley. It's truly an honor to be here. We very much appreciate the invitation from Native Nations Law and Policy Center. Deep respect for the work that you do and the work that the center does. Very much appreciate your work in the areas of repatriation and international indigenous rights, and it's an honor to join you. So thank you so much for sharing that article that was published in November of last year. I've done a few interviews and put out various pieces, mostly focusing on my personal reflections on the impact of the case. And as you said, absolutely correctly, Professor Riley, in terms of a legal issue, it was a relatively straightforward application of existing precedent relating to treaty rights, but its implications to eastern Oklahoma, but also its implications to Native people was profound. It went far beyond the narrow legal import of the case. In terms of eastern Oklahoma, the case obviously impacted the city of Tulsa. The vast majority of Tulsa is in Creek Nations territory, but there's also a large portion in Cherokee Nations territory, as well as Osage Nations. But as you correctly pointed out, many of the formerly known 5 tribes, 5 civilized tribes, now known as the 5 tribes, have similar treaties. But beyond that, there are other tribal nations who would argue that the treaty rights pertaining to their reservation boundaries have never been extinguished or diminished as well. And so the implications are huge. Even though the legal ruling was narrow, the scale of the ruling was undeniably profound. Now, as soon as that case came out, there was a large push for Congress to consider legislation to amend and limit the decision. I'll speak to that more in a bit. But in that discussion about whether or not Congress should act, as well as in the lead up to the issue coming out, there were a lot of false narratives pushed by the state of Oklahoma, as well as, unfortunately, the United States briefs in the case. And those false narratives resounded with me, as well as most people that I know that are students of Indian law, because we're all familiar with this idea that in order to advance policy that justifies the extraction of resources from Indian country, the curtailing of land rights in Indian country, the curtailing of jurisdiction, you have to precede those policy pushes with narratives that soften up the public, that soften up Congress or the courts, that allow for those policy changes to be made. And so those themes I tried to put into that piece that you circulated among your students. I really encourage everybody to take a look. I don't want to take a lot of time rehashing those themes, but let me talk about how those themes impact where we are today. So as I mentioned, the ink wasn't even dry on this historic decision when an announcement was made by the Attorney General of the state that he was putting forward an agreement in principle, which ostensibly had buy-in from all of the 5 tribes, that called for a framework for legislative action, and in it there were calls for the codification of case law, namely Montana, that limit tribal jurisdiction. There were calls for statutorily imposed limitations of tribal rights. And immediately, several of the nations pointed out that, hey, we're not comfortable with this. We're not signing on. So the challenge, the gauntlet was thrown down immediately after that decision came about. And our call was to say that, hey, we have this historic decision that provides an opportunity for all of us to flourish through intergovernmental cooperation, through governmental and corporation cooperation. Let's use the clarity from this decision not to immediately roll back sovereignty, but to provide a framework for joint prosperity moving forward. In other words, our push was to let the concrete set before there was any rush to Congress to fix what we were adamant was not a problem. We were adamant that the McGirt decision brought forth clarity that any student in Indian law would understand that applies to the laws that exist on reservations. Now, they're complicated to be sure, and they're informed by a whole backdrop of a couple hundred years of case law, but we know what rules apply to reservations. They may be complicated, but they're known. Let's use this clarity to build a better future. So that's where we were immediately after the decision was issued in July 9th of last year. And that's where we were in this, all hands on deck effort to prevent and to protect against any rush to legislation in this last Congress. Now we're in a new day, and fortunately, I think cooler heads have prevailed. People recognize that, to be sure, there are numerous implementation issues to be dealt with. I'm happy to speak to those. I'm sure Attorney General Hill will speak to them as well. But these implementation challenges are all part and parcel of the hard work of justice. The work that goes into building capacity of a tribal nation is something that should be embraced by all, that if it's embraced, it provides greater public safety on the ground. It provides better economic opportunities for natives and non-natives alike. And that's where we're at right now. So I'm speaking very generally. Let me talk about some specifics. So in July, in the same month as the decision came out, Chief Hill, who is the principal chief of our nation, who came on board in January of last year, who had been watching these developments as they played out, he announced that our nation was going to form a Reservation Protection Commission. And that's exactly what he did. That commission was made up of 40 or so of our best and brightest operations folks, policy folks, as well as legal scholars. We have some of the best we're very lucky at Creek Nation to have some of the best and the brightest within our ranks. And Chief Hill brought us all together to work on these implementation questions that I touched on briefly. This commission was tasked with looking at every area of criminal and civil law, as well as regulatory arenas that needed to be addressed, and make recommendations to the council and to Chief Hill. That commission has worked diligently over the last 6 months and is prepared to make recommendations very soon to both the council and to our chief. All of those recommendations are unique to the various areas that they address, but there are some commonalities there. They all address building tribal capacity, and that should be no surprise. Creek Nation, as well as many nations, has been hindered, has been obstructed in being able to develop its governmental institutions since the formation of the state of Oklahoma. Oklahoma, as it argued in its briefs to the Supreme Court, was under the mistaken impression, or some would call it wishful thinking, that the formation of their state somehow disbanded our reservation and disbanded our ability to determine our own futures. And so Congress worked with, the state worked with Congress in the early days to limit our court systems, to limit our law enforcement systems. We've been basically handcuffed since the arrival of statehood. Well, with the recognition and the affirmation of our reservation that comes with Justice Gorsuch's brilliant opinion, we now have an opportunity to focus on capacity building. So I know all the tribes that are potentially impacted by McGirt have one thing in common. I think we all agree that capacity building within our nations is critical. But beyond that, the federal government, certainly in the arena of public safety, but also in the civil arena as well, has a trust responsibility to support that tribal capacity building. You know, the 5 tribes are treaty nations. Many tribes are, and the trust responsibilities that adhere to the United States and are tied to our nation flow not from just a generalized set of kind of aspirational trust responsibilities. These are actual treaty rights from a whole series of treaties our nation entered into. And as I always point out, our chain of treaties goes back to the very first treaty tribal nation entered into under the new Constitution, under the Constitution that we know today, the Treaty of New York in 1790. So our commission's developing recommendations that focus on capacity building, as both on the tribal side, but on the federal government side, not for the purposes of dealing with chaos, but for the purposes of building up institutions so that over the long term, everybody's interests are protected. We've invested over $4 million in the last couple months of our hard-earned resources, or critical resources that are very much needed on an operational level to beef up our court system, to hire additional prosecutors, public defenders, social workers, on and on. We've revamped our codes. We've entered into child welfare compact with the state. We've beefed up our cross-deputization agreements. At the time the McGirt decision came out, there were over 40 cross-deputization agreements in place, or I'm sorry, intergovernmental agreements in place. I think we're around 70 right now. We're doing what we can to make sure that the concrete sets on this decision, that we show to the world that yes, we're going to have ups and downs, but again, this is the hard work of justice, and we're going to do whatever we can to show that this decision is not just good for Creek Nation, but it's good for everyone within our borders. But in order for us to fully prosper together, we're all going to have to do the work together. We can't chicken out. We can't run to Congress and just say, hey, we're as bad as it was, we're used to the way the old broken system worked. Can we go back to that? We're not going to do that. We're focused on building a better future together with all of our partners. And I'm happy to get into specifics. I know that's a 30,000 foot summary, but I don't want to eat up all of the time of this program. So thank you, Professor.
Thank you so much, Ambassador. And I am going to circle back around to you, of course, with some more detailed questions, but thank you for that overview and for sharing your insights as an ambassador and as a citizen of the Creek Nation. It's really incredible to hear what's been happening. I want to turn now to Attorney General Hill. As Ambassador mentioned, the 5 tribes in Oklahoma, which when I was growing up, they were called the 5 civilized tribes, and now they're called the 5 tribes. Maybe you lost the civilized along the way, Ambassador, but one of those is the Cherokee Nation, and there is at least more than a subtle suggestion, and there have been a few court rulings that indicate that legally the other 4 of the 5 tribes are very similarly situated to the Creek Nation and may have very similar impacts under McGirt. As the lead attorney for the Cherokee Nation, I would love to hear from you, Attorney General Hill, on what's been happening there on the ground and what you see as some of the potential impacts of this case for your nation moving forward.
Sure. Thank you so much for the invitation to speak. LA's traffic usually makes me not want to be there, but with the weather I've got here, LA sounds lovely. And so I'm going to try to get some warm weather just from the Zoom screen, if that's possible from you guys. It's also an honor to always be on a call where I get to listen to Ambassador Chaudhuri speak about his experiences. I've heard it a few times now, and I always enjoy an opportunity to hear him talk about the Muscogee Creek Nation. I don't know if we became less civilized or if everyone got more civilized, but we're just the 5 tribes now. And I think that and the legal history of the 5 tribes, how tied together the 5 tribes are through history, is part of, what makes McGirt have such a broad application, I think, to most legal scholars. In most legal scholars' minds, that the application is very broad. If the 5 tribes tended to sort of be treated as a block historically. So during the Indian removal era, the 5 tribes were being removed from the region that we all came from at the same time, and under very similar treaties. At allotment, the 5 tribes were allotted under separate agreements differently than other tribes were. So that's just, we've been treated sort of as a block, a political block of our own, intended to collaborate, have a long history of collaborating and working together over now, centuries of interactions with the United States. So because of that, I think it's pretty clear that the decision in McGirt is going to have a big impact in Oklahoma and a big impact on the other 4 of the 5 tribes. There have actually been in the district court. So these cases are already, this is not a possible impact. It's a direct and occurring impact. If you want to watch watch what's going on, you can see it happening right now. There have been several cases, I think 11 or 12 cases remanded from the Oklahoma Court of Criminal Appeals back to the district court saying, we want you district courts to look at the facts here and make a determination about whether or not the Cherokee reservation has ever, if it was established, and if it was established, whether it had ever been disestablished. And every single state court that's heard it has decided that the reservation was established and was never disestablished. Which may speak to the legal skill of the lawyers involved, but maybe speaks more to the fact that the Oklahoma Attorney General did not contest it. There was no evidence provided by the state on the other side. They never argued that the Cherokee Reservation had been disestablished because of the very similar legal history and the similar treaties. Looking at the treaties of the Cherokee Nation and the Muscogee Creek Nation, there's just no basis upon really which to differentiate them and say that there was some fact that would have made a difference in the Cherokee Nation that would lead to a different result than the result the court reached in McGirt on the Creek Nation. So there was no argument on the other side, that no one was saying that the reservation had ever been disestablished. So all of the courts, the state district courts made those decisions. Now it's gone back up to the Oklahoma Court of Criminal Appeals, where they get to decide whether they agree with the district courts or whether they want to say something different. And that decision could come down, and every Thursday is when the court releases criminal opinions. And so every Thursday is a new opportunity for the state's courts to decide, appellate court, criminal court, to decide whether or not this is going to apply throughout the other remaining 4 of the 5 tribes. And I think no one really questions the outcome. It's just a question of timing. So this Thursday, they could release decisions in all of the other four of the 5 tribes. We just don't know. I want to introduce you, having talked a little bit about, why this has broader application than just the Muscogee Creek Nation. I want to talk to you a little bit about my tribe, the Cherokee Nation, and a little bit about the reservation that the Cherokee Nation has, and talk to you about the changes that we've already begun to see, and help you maybe grasp a little bit what criminal law enforcement on Indian country looked like prior to McGirt in Oklahoma on the 5 tribes. So the 5 tribes, Oklahoma has always argued that the tribes had no presence, had no physical presence in the state, that after statehood, the tribes had no courts, they had no jurisdiction, and all of that somehow magically went away at statehood. Now, we know from McGirt that that's not the case, but these were the arguments that were made early in Oklahoma's history. So their original argument was that there were no tribal governments, there were no tribal courts, there was no remaining tribal authority in the state. And it really took, decades of court cases for there to even be any sort of enclave of tribal authority, for there to be decisions and agreement by the courts, the state courts, that there were these enclaves of tribal authority. And they didn't do it voluntarily, of course. They were forced to acknowledge these because of the federal court decisions that they received. And so they began to be these pockets of places where they agreed, okay, tribal courts can't be suppressed anymore. And they have jurisdiction over at least tribal restricted land, which in Oklahoma's 5 tribes, individual Indians can own land in what we call restricted fee status, which meant it was Indian country. And the tribe could exercise jurisdiction over those pieces of individually owned restricted fee. And then the tribes also took land into trust, or the United States took land into trust on behalf of the tribes. And over those parcels of trust land, the United States could exert jurisdiction. I mean, the tribes could exert jurisdiction over those parcels as well. So now we've begun to carve out in Oklahoma, in the 5 tribes, inside the boundaries of the reservations, these enclaves where even the state would say, okay, the federal courts had decided we're forced to acknowledge tribal authority over these parcels. And eventually that went on to include some dependent Indian communities, not a lot, but a few places that are considered dependent Indian communities. And that was basically the footprint of tribal authority in Oklahoma prior to the decision in McGirt that everyone agreed upon. It wasn't that the tribes didn't believe that the reservations existed, but these were the parcels over which there was agreement from the state, from the United States and the tribes, that the tribes could exert jurisdiction over these enclaves inside the reservation boundaries. But it was a pretty small amount of property. There's not a lot of restricted fee land left owned by individuals, because for years there were special rules in the 5 tribes that said if you were less than 1/2 blood quantum of the 5 civilized tribes, you couldn't have restricted land. Your land went from being restricted and being under the jurisdiction of the tribe, and it lost that status once your blood quantum got below a 1/2 blood quantum of the 5 civilized tribes. So that, which I mean 5 tribes, that language still appears in the statute. So it says 5 civilized tribes in the statute. And so those, of course, there wasn't a lot of that kind of land left. The tribes, the land into trust, I mean, it was just a tiny patchwork. If you looked at the map of the Cherokee Reservation, you would have seen tiny little squares all over the 14 counties. And that's what the tribes have exerted criminal jurisdiction over. And everyone agreed that the tribes could exert criminal jurisdiction over those parcels. So I say that to say, that was what our system was designed to do. Our criminal justice system was right-sized to that amount of jurisdiction. So we had the number of police officers, which we call marshals, tribal police, to patrol that small area. The tribal courts exercised jurisdiction, was used to that number of cases. And the tribal prosecutor's office, my office, handled cases from those locations. So with that in mind, think about now the world post-McGirt. So in post-McGirt, now you have, let me describe the Cherokee Reservation for you. It is 10% of the land base of the state is the Cherokee Nation. It's 7,000 square miles of Oklahoma is the Cherokee Reservation. 513,452 people live in the Cherokee Reservation as of the most recent census, not the most recent census, the one before, I think, but it kept updated. So more than 500,000 people live in the Cherokee Reservation. Approximately 143,000 of those people are Cherokee citizens. And so that means about 28% of the total population of the reservation is Cherokee. So the nation went from having jurisdiction over a relatively small bite of that to having now criminal jurisdiction over the entirety of the reservation, all 7,000 square miles. The Cherokee Nation has jurisdiction over all of the Indians, not just all of the Cherokees, but over all of the Indians who live on the reservation. So, the number 143,000 of them being Cherokees, and will be by far the biggest chunk of that will be Cherokee citizens. But that's not all of the Indians that live there. There's still a lot of other different types of tribal citizens that live inside the jurisdiction. So that's just a snapshot of what the challenge is. We go from having a police force that is prepared for one size, and now we're having to adapt to a much larger jurisdiction. And of course, the Muscogee Creek Nation has been facing a similar challenge for longer, and they have a much more urban area because they do have the biggest chunk of Tulsa by far. And that particular area of Tulsa and Wagner County that the Creek Nation has is a hugely growing suburban area. So they've got really just a huge population in Tulsa and Wagner County. In 2019, the Cherokee Nations filed 62 criminal cases. So that was the level of cases that we had in 2019. Estimates of what we expect to file in the year that comes after the court's decision and the cases began to be dismissed in the Cherokee Nation, as we anticipate they will go estimates, just in domestic violence crimes, using data from 2019 reported by the OSBI, the Oklahoma's law enforcement entity. I estimate about 614 just domestic violence crimes would be filed in the Cherokee Nation involving Indians. Now, that doesn't necessarily mean the tribe would have jurisdiction, because if a non-Indian commits a crime against an Indian, the tribe can't exert jurisdiction over the non-Indian in most circumstances, although it's different for domestic violence crimes. But for most crimes, the United States has jurisdiction over those cases where it's a non-Indian who commits a crime against an Indian. But because these are domestic violence crimes, we may have all 614 of those. 8,376 estimated assault and batteries in the jurisdiction. So these are the numbers I estimate, given, and we had 62 criminal cases filed in 2019. So I say all of that to give you some sense of scope about what the challenges are in terms of trying to put together a law enforcement. Oklahoma had 100 years to build the law enforcement system that it has today. The tribes are really being asked to build, new systems more or less overnight. Detention cost in 2019 at Cherokee Nation was $23,940. That's how much we spent in detention in 2019. Estimating just the cost of detention in county jails. Now, this is not talking about people who may be sentenced to longer terms in prisons, but just in county jails, we estimate around $6,485,000. So in excess of $6 million for detention, just for the county jail detention. And that's actually pulling pretty good data. Me looking at taking snapshots of jails and the number of people in that jail who we know are Indians. It could easily be, when we talk about the longer term detention issues, it is not unreasonable to expect that the budget for detention could exceed $20 million a year. Because of course, as you have these longer sentences that get stacked up, then those are consistent drags on your budget. So if someone's spending 9 years in prison, then that's a 9-year drag on your budget that you have to account for as you're moving forward. So it's cumulative to some extent, especially at first, because there's nobody getting out. There's only people going in for a while. So aside from the detention costs, there's also other costs that go along with that. We have to increase the number of court staff. We have to increase the number of courthouses. At statehood, the Cherokee Nation had 9 courthouses spread throughout the Cherokee Nation reservation. And of course, those 9 courthouses at statehood were mostly taken from the tribe completely and turned over to the state to become their property. And we have one of the original courthouses is still standing, but not in a location where there are a lot of people today. So we're going to have to go out and find new courthouse locations, which is something we're working on. We have to increase the number of prosecutors, which I've been really busy. I'm interviewing people today for new positions for prosecutors in the Cherokee Nation so that we have the staff that we need to try these criminal cases. A lot of the cases that we're getting are cases that have been dismissed from the state court, but have been previously tried there. So you have to take the discovery, go through all of the criminal discovery that's happened in the past, see what witnesses are still available, who can testify. So you have stale evidence issues or complicated cases, and they're serious cases. Some of the first cases I've been sent are manslaughter cases. So these aren't speeding tickets. I mean, these are cases where the stakes are high, and providing justice for those victims demands nothing less than the very best effort that we can give it, because we know that these cases are going to be dismissed. It includes building a new juvenile division. So juvenile offenders, the state lacks jurisdiction over juvenile Indians who commit offenses on the Cherokee reservation. This is not something that the nation had ever done very much of. We'd only had a handful of juvenile detention issues ever in the nation's history. And now that's going to be a very significant area where we have to build an entirely new department to handle those issues. Technology upgrades. So if we build new courthouses, do they all have to be filing courthouses? Do I have to have court clerks in all of these courthouses, or can we use an online system? What about all the speeding tickets that get issued? So South Coffeyville is more than 2 hours, which is in the most northern part of the Cherokee Reservation, is more than 2 hours from our courthouse. If you get a speeding ticket in South Coffeyville, how does that ticket get paid? Can we use technology to try to make those offenses easier to prosecute and more convenient for our citizens? And then, of course, our criminal code had to be completely updated to try to make it more consistent with Oklahoma's criminal code, because one of the issues we have, which I don't want to take up any more time, but the policing issue is another big issue that we have to deal with. And having a consistent criminal code that's familiar to law enforcement will help on the policing side. So we've been doing a lot of that, plus a $10 million infusion to help pay for all of these upgrades that we think that the nation needs. So that was part of our own sovereignty commission, similar to what Muscogee Creek Nation had. And that was one of the recommendations that we had. So that's just a fairly brief overview of some of the issues that we're dealing with on the Cherokee Reservation as we dig in and get ready to do what we know that justice demands we do.
Wow, thank you so much. That is an incredible overview. And I am going to turn back to Ambassador Chaudhuri, but before I do, could I just ask you one follow-up question? When you mentioned that a lot of the cases that you're getting in the criminal courts are ones that have been dismissed by the state, so are these cases that have been charged but not fully prosecuted yet?
No, these are people who are currently serving sentences in the Department of Corrections for a crime that they committed. So they committed a manslaughter, were convicted of that crime in the state courts. But we know they haven't been dismissed yet, but there are these remand cases that are hanging, and we know they're going to be dismissed. So rather than, now the state cannot dismiss their case until they get some decision from an appellate court. But my reservation has always been here. I don't have to wait for them to file my case, and I'm not going to. So we're filing the cases in tribal court in anticipation of those dismissals, so that when they're dismissed, we just go pick them up in their orange jumpsuits and we just take them to a different detention and put them right back in jail for the crime that they committed until we can get them retried in the tribal court.
Wow. Okay, great. Well, there are so many juicy legal issues going on there. I can't even begin to delve into. I want to come back to you. Let me ask Ambassador, if you could say a little bit more. You were going to talk about some of the more specific examples of what's been going on at Muscogee Creek Nation and sort of the on-the-ground consequences. And I know Attorney General Hill provided some comparative data for Cherokee, which is, I think, really interesting. And I don't know if you could give us a little snapshot of the before and after for Muscogee Creek.
Sure. And, my role is largely a policy role and a diplomat's role as ambassador. My hat's off to AG Hill, as well as our AG's office and our Light Horse and Cherokee Nations for all the day-to-day work that everybody's doing to make this work. Our numbers are comparable, but let me just say there have been coming from policy and diplomacy perspective, I'm more mindful of how numbers or how events get portrayed. There have been a few case transfer issues that I don't want to throw our county or state counterparts under the bus, that I don't think would have been an issue if folks were talking and coordinating as efficiently as they can be. We're dealing with these intergovernmental cooperation issues on the ground in real time, but the opponents of tribal sovereignty, the folks who want McGirt implementation to fail, will always point to this situation, this one case or that one case as a poster child for why chaos is running amok. Now, fortunately, I think people have been smart enough to see through that. But to be clear, there are going to be implementation, challenges. This is going to take work and a lot of money. Our numbers are very comparable to Cherokee's. I mentioned the $4 million investment that we put forward. I'm not able, because it's not cooked yet, to share what number we think we're going to need, at least on the Creek Nation side, to kind of fully build into this newly affirmed sovereignty, but it's certainly comparable to Cherokee's. But this is a good thing. Let me just point this out. Cherokee Nation, Creek Nation, we do have similar histories. our histories are ones of working and living side by side and with non-native partners throughout our entire history. We understand, if we're allowed to do it, we understand collaboration. The history of Oklahoma is not always a bright one, but we've lived through it. Non-natives have lived through it, and here we are. The reason people are hopeful with the folks that aren't buying into these kind of platitudes of fear is that they know that when it comes to receiving services, Cherokee Nation, Creek Nation, Choctaw, Chickasaw, Seminole, we're great partners. At Creek Nation, our clinics serve natives, citizens, non-citizens alike. Our entertainment services serve citizens and non-citizens alike. I think folks who know us best, folks who live in our communities, haven't, for the most part, fallen prey to these false narratives. But our numbers are certainly comparable. Let me mention another reason why this is a good thing. Yeah, we've taken on a lot more volume of cases than we had before, but compared to the overall criminal activity in Eastern Oklahoma, we're still talking about a small subset of cases. We're talking about cases involving almost exclusively tribal defendants, tribal member defendants, or citizen defendants. The reason that's critical is, all these the sky's going to fall narratives from the state suggest that all defendants will run loose. Well, yeah, this is a big deal for Creek Nation and Cherokee Nation, but you're still talking about tribal citizens. And the reason I keep qualifying that is there's very limited authority in the VAWA context over non-citizens, non-natives. So you've got this group of defendants and these groups of crimes that more often than not involve native victims that haven't always been aggressively prosecuted by the state. And let's be honest, I mean, we seek to build on our relationships with the state, but when you have limited budgets and your own financial issues, you prioritize things as necessary. Our nation's had a history of doing whatever we can to get our partners to prioritize our cases and prioritize safety within our lands the best that we can. The ability to do that directly and the ability to go after bad guys directly and to do so hand in hand with the federal government, we relish that opportunity because we believe in public safety in Creek Nation, and we recognize this is going to cost a lot of money. We're committing our own money to it, but we also understand everybody has a role in investing in capacity building for the future. The way that we look at it, there are only two paths moving forward. One is of increasing tribal capacity, increasing federal capacity. The other is decreasing tribal capacity and decreasing federal capacity. We're firmly of the belief that the path to prosperity involves increasing our capacity. And so what does that mean? When we met with Attorney General Barr last year, our ask was that in addition to any short-term capacity building for the U.S. Attorney's Office and for Creek Nation, we roll up our sleeves and push for long-term settled appropriations so that there's a recognition that, yeah, maybe all the institutions were sized to fit one ill-informed view of jurisdiction before, but now given the real landscape that we're dealing with, let's commit to this and make this part of our ongoing institutions. We don't need to dismantle this historic Supreme Court opinion, but what we do need is to invest in the future. And if we make those investments, we'll all have a better future for it. And so the numbers for us are considerable, they're comparable, but the way that we look at the day before McGirt came out, folks who committed crimes in the subset of cases that McGirt addressed could be prosecuted by one jurisdiction, namely the state, who was historically cash-strapped, who may not have always prioritized these cases, but the day after, under the law, those same cases could be prosecuted by two superpowers. You could, by one tribal nation whose existence precedes and predates the state of Oklahoma, who, if you believe in local decision and local control over decisions, you'll understand that nation has the most to benefit in protecting the public safety. That's the first superpower. And the second superpower is the United States of America. The McGirt decision was a bad day for bad guys. We just need to invest in capacity building to make sure that we have all the tools we need to move forward.
Great, thank you so much for that. I'm going to tell my participants, if you want to put questions in the chat, please go ahead and put those in. My colleague Lauren Van Schulfbart is going to be taking a look at that. But before we go on to questions, I want to go back to A.G. Hill with a couple of questions, and I wanted you to pick up on. Both of you have talked pretty extensively about intergovernmental agreements and interjurisdictional cooperation, which is absolutely necessary in a place like Oklahoma, which I'm very familiar with too, given that we have so many tribes and so much checkerboard reservation land given allotment. And so I'm really interested in hearing a little bit more about what Cherokee Nation has done in that regard. And you mentioned specifically a few places that I think our audience would be really interested in hearing, things like making the criminal code match between the tribe and the state, how you're dealing with policing, who has arrest authority and where, over whom, and for what crimes, and how are you dealing with those things by agreement to try to resolve some of the really, some of the technical issues that could sometimes make public safety more difficult than it needs to be unless things are clarified in advance.
Yeah, those are the things that I am wrestling with on a day-to-day basis. On the one hand, you've got, the United States has expanded authority on a reservation than what it normally would have in other places in the United States. So there are circumstances where, and this all ties back both to prosecution and to policing. If a non-Indian commits a crime against an Indian, then the Cherokee Nation and the state are both void of jurisdiction. So if an Indian is committing a crime against a non-Indian, then the Cherokee Nation could step in and prosecute the defendant because they're a tribal citizen or they're an Indian on the reservation. If the reverse happens, if a non-Indian commits a crime against an Indian, then it's the United States that has jurisdiction. The U.S. Attorney's offices historically have not done a great job of law enforcement in Indian country, and they've got a long and checkered record on law enforcement in Indian country. In Eastern Oklahoma, in the Northern District, there's two U.S. Attorney's offices in the Cherokee Reservation, the Northern District and the Eastern District, and both of them are not really, like the Cherokee Nation, are not sized for the kind of jurisdiction that they're now tackling. And I think that's what the ambassador was alluding to, the need for resources in those offices, because they are not up to the task today. And I think that none of the people in those offices would say that they are completely up to that task today. But all this goes back to policing as well. So there's also, talking about arrest authority. If a crime occurs on the Cherokee Reservation in, let's say, a rural county like Delaware County, we have cross-deputization agreements. That's what I think deputation is actually the right word, but everyone in the whole world says deputization. We have these agreements which allows if I'm a county police officer in, let's say, Delaware County, which is a pretty rural county, in Delaware County, they have a cross-step agreement with the Cherokee Nation, so that county officer, if he pulls over on an Indian, he doesn't have to worry about whether or not that's a tribal arrest or a county arrest. He can just make the arrest, and he can put on a tribal hat, a Cherokee Marshal hat, if he needs to, because he's got this card which says I'm cross-commissioned with Cherokee Nation, and I can stand here and be a tribal officer, or I can put that card away and I can be a Delaware County officer. And that cross-deputization gives him that power to be an officer for either jurisdiction that he needs. But what if there is he comes into a place and there's been a crime and it's a non-Indian who's committed a crime against an Indian? Well, his state card is no good there, right? Because the state doesn't have jurisdiction over that crime. his tribal card is no good there because the tribe doesn't have jurisdiction over that crime. For him to have the right authority to make an arrest in that circumstance, he needs the United States authority, which means he needs some kind of authority that he gets from the United States. There's two different ways that he could get that. One is through what they call SLEC, a Special Law Enforcement Commission, that they give that officers can get from the United States. And the other one is a TFO, a Special Task Force officer, or he has to call someone from the FBI, right, or from someone from the BIA who already has those commissions to come to his county. Now, those SLEC and those TFO credentials are not easy to get. You have to have an adjudicated background check. You have to take a class. You have to pass a test. And in a lot of counties, and in Delaware County, I know there's not a single officer in that county who has an SLEC or a TFO certification, which means, and they're, more than an hour from Tulsa. So if an arrest has to be made and it's a non-Indian who's committed a crime against an Indian, he's going to have to call those offices and try to get someone to respond from the FBI or from the BIA in those circumstances. So that's a policing issue where there still has to be I sometimes joke, this is advanced intergovernmental cooperation we are engaging in here in Oklahoma, having a better network of the tools so that every officer has the tools that they need jurisdictionally to do their job is incredibly important. And then having the United States have the right number of people to do the job that they need to do. All of these issues are issues that we're dealing with. And one of the ways to deal with that, I know Cherokee Nation has had an interest in, is finding some way. Is there some way where we could have jurisdiction sharing agreements? And in the ICWA agreement, the state and the tribes were able to agree that Oklahoma should maintain jurisdiction under these certain circumstances as the tribes permitted and allowed. And is there some corollary like that that could be useful for tribes in the criminal context to help wrestle some of these issues to the ground and close any issues that may arise, inside our jurisdiction? So those are some of the practical issues that we're still wrestling with. What's the best way to do this? And are we making sure we're covering the policing, the prosecutorial, and all the different issues that arise in these contexts?
And if I could, touch on that, those are great points that AG Hill raised. As I mentioned before, the rules applying to reservation, they're not new. I mean, tribal nations throughout the country deal with these interjurisdictional issues. In a previous life, I just want to share kind of one previous experience. Used to work in Arizona and for a while practiced criminal law in Maricopa County. The power to arrest and detain, not necessarily prosecute, but arrest and detain is much broader than the subject matter jurisdiction involved in actually prosecuting the case. So in Arizona, we'd have situations where in a 1 square mile area, you had tribal jurisdiction at play, county, city, state, and federal, all packed into 1 square mile. And you could address some of these things through cross-step agreements, and folks had a lot of time to enter into these agreements. So they developed over time, and there was a very robust framework for cross-step agreements. But some of it comes down to kind of the inherent, without getting into too much criminal law here, and I don't want to kind of get into A.G. Hill's wheelhouse, but the power to arrest and detain is broad. And where there's a will, there's a way with a lot of these things. And that's one of the things that I know our commission's looking at, but it all starts with cooperation and commitment from all jurisdictions involved. And that's what we're trying to get everybody on board with, getting everybody invested to making this work in the long term, rather than focus on rolling things back.
Well, thank you for that. And one of the questions that was raised on the criminal side, I want to just sort of bring up here. So for the audience members, some of you don't know, many of you do, but some of you don't know, that after a Supreme Court case called Oliphant, tribes in general don't have criminal jurisdiction over non-Indians who commit crimes in Indian country. And as Ambassador said, there is a relatively small carve out for certain crimes of domestic violence under the reauthorization of the Violence Against Women Act. But it's a relatively modest statute, and it covers a relatively small number of crimes, and tribes have to have opted into it in any case, and not every tribe has, partially because of infrastructure and capacity. So I guess one question that I would have is, given sort of what McGirt has meant for criminal jurisdiction in Indian country and the increased or at least certainly continuing complexities around criminal jurisdiction, do you think this is going to reignite some of the advocacy around an Oliphant fix? So for my audience, that was the name of the Supreme Court case, which was Oliphant. So whether there'd be some effort to get some sort of statutory or legislative fix to Oliphant so that tribes would have essentially criminal jurisdiction over all crimes, or at least over all defendants in Indian country, maybe in partnership with the federal government. Do you see that as being something that tribes will be interested in moving forward, or and maybe in your own experience, whether it's something you're seeking?
I definitely want to address that, but I spoke last. Maybe A.G. Hill could take this one and I'll follow up.
Sure.
Yeah, I think that, there are things that I'm perhaps less qualified to speak on than others, and the politics of how and under what circumstances Congress would consider an Oliphant fix and allow tribes to exert jurisdiction over non-Indians is something that is beyond my capacity to see, whether that would be possible or under what circumstances that would be possible. I do know that the issue of, even in the treaties of the Cherokee Nation going back, a very long ways indeed, there was this agreement between the United States early. The United States was supposed to remove people who, their own citizens who violated the laws, was supposed to remove them from the Indian country of the tribes. And the United States failed to do that. And I think, and that has been, and of course, that encroachment into tribal territory and their unwillingness to provide for real tribal authority and autonomy inside their own jurisdictions led to the circumstances that have been created today. Reversing that, I think, would be politically challenging in our environment today, which is not to say it wouldn't be desirable or that it shouldn't be something that people should work on, but how the politics of that, of having someone who cannot vote in the tribal election yet be subject to the laws of that tribe, it seems like that would be politically complicated to accomplish.
So I agree with A.G. Hill's assessment. It's challenging, but I think there's momentum building for an Oliphant fix. And so I'm a little bit resistant to tie the McGirt discussion to the separate discussion about whether or not an Oliphant fix makes sense, because I've got to be frank, there's so much fear mongering that is pushed in both arenas. With McGirt, I already mentioned before the narratives about the sky's going to fall, criminals are going to run rampant, and this is going to be bad for business. And those were false narratives. In Oliphant, let me just speak very briefly, and I'm going to steal a talking point from my significant other who points this out. Rehnquist had to come up with a false narrative to justify Oliphant. And the false narrative he pushed and the decision was that, tribal courts are not courts of meaningful capacity. They're these new, they basically called them, I can't quote it, but basically called them kangaroo courts. And that, how would one feel to be brought into a tribal court where you can't vote in a tribal jurisdiction and you can't serve on a jury, yet you're subject to tribal laws? Well, there are so many false narratives to unpack within the Oliphant decision. First of which, as A.G. Hill points out, many tribal nations, including Creek nations, as well as Cherokee nations, have judicial systems that predate the United States. In addition to treaty terms, Creek Nation, like Cherokee Nation, had provisions that allowed us to prosecute crimes committed by non-Indians, and allowed us to prosecute crimes committed against women. And we did, and Cherokee Nation did. But they had to create this fiction, Rehnquist had to create this fiction that tribal courts were kangaroo courts, were new things that shouldn't be recognized within the American judicial framework to get to his decision. And similarly, this idea that because somebody doesn't vote or serve on a jury, they can't be hailed into a court. Where in the United States is that the standard? If I go down to New Mexico and I violate New Mexico law, I fully am aware that I'm going to be subject to prosecution under New Mexico law. I can't serve on a jury in New Mexico, but if I violate their laws, I'm going to be in court in New Mexico. So Oliphant, this does tie into Oliphant. I mean, it's like, so many of these arguments about, oh, this is going to be complicated. It's like, it's analogous to kicking a dog and wondering why it limps. You've got this framework that was created by design in many ways to limit self-determination by tribes, to basically push these false narratives. And now you're saying, well, it's complicated figuring out who has jurisdiction here, who has jurisdiction there. Well, why is it complicated? It's complicated because because of cases such as Oliphant and other restrictive laws. Now, if you come from the perspective of recognizing that local decision-making and local problem solving are good things, and whether you're native or not, you should support tribal empowerment, because that will protect people on the ground, that will spur business on the ground. If you start with that presumption of respect for tribal nations as actual governments, with an interest in protecting public safety and promoting economic development, then everybody wins. But unfortunately, the history of Indian law hasn't been one of pure respect for tribal nations and tribal governments. That's why we have this chaotic, split personality case law that we deal with. And Oliphant is one of the best examples of that. So I agree it's politically difficult to get an Oliphant fix, but let me tell you, being in DC right now, that is the topic of great discussion. And it's the topic of discussion from both sides of the aisles, realizing that public safety is important both for natives and non-natives. And one of the purest paths to protecting people's interests is addressing this crazy situation that Oliphant created. And I can't say if it will happen. I think it would be a great thing if it would happen, but it comes down to public education. When folks hear that a tribal government may have jurisdiction over them, they could see that as an opportunity, or they could listen to fear mongering. And unfortunately, there are plenty of fear mongers who try to point that out as a scary thing for non-natives. But it doesn't have to be. It's actually a good thing. And it's very akin to me going down to New Mexico and just simply respecting the sovereign laws of the state.
Great, thank you so much for that. I want to shift the conversation to some of the civil regulatory issues and taxation in particular. So as you all know who've read the McGirt decision, and Gorsuch was very clear that the issue as presented to them was very narrow, and it was specifically with regard to the borders of the Muscogee Creek Reservation for purposes of criminal jurisdiction under the Major Crimes Act. The opinion is also written, I think intentionally, quite narrowly. But it has raised the question for many tribes, and I'm assuming for both of yours, and I know for others, which is, does McGirt extend beyond the Major Crimes Act and criminal jurisdiction context? Can it or should it extend to the regulatory jurisdiction context and taxation in particular? And of course, for my audience and for my students, just to put a fine point on it, you can imagine where criminal jurisdiction, although incredibly important to all sovereigns for issues around public safety, criminal jurisdiction is very costly and not revenue generating in general. Taxation is revenue generating, and sovereigns that may not want jurisdiction under some circumstances may very much want jurisdiction under circumstances involving issues like taxation, because it's how they raise revenue. So it's an issue for tribes, for states, for others. So I'm curious to hear both of your, one of the questions that we've had presented is to talk a little bit about whether there is going to be any effort to extend this McGirt rationale to the civil regulatory context, especially with regards to taxation, and also maybe more broadly, how do you see McGirt tying to Indian country economic development, if at all? Thanks. And I guess A.G. Hill, I'll start with you.
I think there can be no question that there are going to be impacts in the civil regulatory space. specifically talks about the Major Crimes Act, but 18 USC Section 1151 is incredibly important in multiple areas of the law. I mean, that's the definition to which many other laws refer, and the being on a reservation, and that has consequences that go beyond just the criminal law context. A reservation for a purpose. There would be a very unique circumstance where there was a reservation under the law that existed for a singular purpose. That's not what homelands are for. A reservation has broader context than that. So I think there are definitely going to be some civil issues and taxation issues that get raised. And it's not necessarily because the tribes are going to raise them, but because they're going to get raised by individuals who may be affected by that. So if you are a citizen of the Creek Nation and you are paying income tax to the state, or the state is telling you that you owe them income tax, you may decide to challenge that and say, well, I'm in under the McClanahan case, typically a citizen of the reservation who lives on their tribe's reservation, whose income is derived from sources on the reservation, is exempt from state income tax. The state will probably say, well, McClanahan's facts were a little different. The Arizona Navajo reservation is a little different than your reservation is. And they may want to argue that point, but it's not going to be up to the tribes to determine whether or not those issues get raised. They're going to get raised because those are individual citizens who will raise them. And I think the same is going to be true in other contexts, like the income tax, the sales tax context, and other places where individuals are going to see the potential for economic opportunity, and they are going to seek to evade state taxation. So I think there is no question that there's going to be continued litigation on the issue of both regulatory and civil jurisdiction. And it may not be the tribes may not be the litigants in that. It may be individual Indians who are litigants in that.
Great, thank you. Yeah, I mean, that raises an important point, which is that a lot of the cases that we've ended up with in Indian law and that we deal with don't even necessarily, I mean, they're not cases that are necessarily brought by tribes, right? They're issues that come up through the courts that can't be foreclosed. And they will. Yes.
Right.
Yes, thank you for that. Yes, Ambassador.
Yeah, and I would just add, and I agree with A.G. Hill's assessment. I would just add that this isn't a scary thing to non-natives. And the Supreme Court did clearly say, for purposes of 18 USC 1151, this is Indian country. Creek Nation's Indian country under the law. And that brings with it all sorts of implications. But again, back to the fear mongering. You see commercial corridors on tribal lands throughout Indian country. The fact that you can set a tax rate that encourages investment, that encourages business, that's a power of any government that any government has over its lands. Anybody that thinks that this is going to be irresponsibly wielded by the tribal nations of Oklahoma is just wackadoodle, to use an Oklahoma term, because tribal nations have a great interest in bringing business to Eastern Oklahoma and throughout Oklahoma. Now let's talk about tax rolls, though. If there's some short-term concerns about tax rolls, I would simply say, let's cooperate and let's work together and let's figure out win-wins. There's a great example that I always try to bring up of one tribal nation who, who worked with a county. This is in Arizona. I don't want to go into too much detail, but worked with a county to collect state taxes from non-citizen employees. So just without going into a whole tax discussion, the tribe was under no obligation to actually collect the payroll taxes of non-citizen employees and remit them to the state or the county. Now, it was a county responsibility. It was an administrative burden that the county had to bear. But these employees were within the tribal system. They were part of the personnel system of the tribe. It was very easy for the tribe to do that. And so the tribe simply said, hey, let's not be adversarial. Let's figure out some cost sharing agreement where we do this administrative task for you and you reimburse us a reasonable rate. Deal? Deal. Everybody wins. Same thing with potential dual taxation issues. Without a doubt, and the dust still has to settle, but I agree with A.G. Hill's assessment. There is going to be, extended authority, but that's not a bad thing. If the tribes and the counties and the state understand that setting price points for tax revenue coupled with cost sharing to arrive at a place where everybody wins is the goal, then we can do everything. I mean, this is a simple math problem at the end of the day. But if folks are adversarial and just are afraid of change, it's not going to work. But if we're intelligent about it and take lessons from other reservations throughout the United States, we're all going to win. I mean, in Tacoma, a large part of Tacoma is within the Puyallup Reservation. In Green Bay, Wisconsin, a large part of the reservation is on the Oneida Reservation. There are people, there are non-natives and non-businesses functioning just fine throughout tribal nations throughout the country. How do they get to a point to function just fine? They work it out and they come up with price points that work, jurisdictional agreements that work. This is just what you do as sovereign nations. And so I do think there will be implications, but the real challenge is going to be messaging this in a way that doesn't tap into people's into any knee-jerk fear of change.
Well, thank you for that. And we do have a little bit of time, and just to stick with the civil context for a second, and we've talked mostly about taxation. Could you say a little bit more about environmental regulations? Because I know in the wake of the decision, the governor of Oklahoma, as I understand it, made a request to the EPA to allow state jurisdiction over Indian lands with regard to environmental regulation. I may not be getting that absolutely correct, but I know that there was a lot of controversy around that. So being environmental regulation slightly different from taxation, because we know a lot of taxation issues do get resolved with interjurisdictional agreements. And maybe environmental regulation does as well, although pollutants and other things tend to be migratory and can be more complicated, where upstream and downstream activities impact other people maybe in more profound ways. So I'm curious, what is going on with the environmental regulation in Oklahoma after McGirt? And where do you see the tribes and the state standing with regard to the EPA?
I don't want to chew up all the time, but I'm happy to address that, A.G. Hill. I don't want to take. I spoke last. If you want to take it first, you're on mute, I think.
So I mean, I can just briefly say, what you raised, Professor, was correct. There's been and it was not a McGirt related thing originally. In Oklahoma, typically tribes can receive treatment as state to implement federal standards. So if you are a tribe, you can receive from the EPA the authority to implement your own, say, water quality standards, air quality standards, and enforce those on your reservation. And a lot of tribes do that. The EPA will actually assist the tribes. They have technical assistance programs so that you can implement your own standards and create and implement your own standards. That's incredibly powerful because, as you mentioned, most pollutants they migrate. They don't respect borders. So if you don't have federal authority under these interstate pollutants to block them with EPA authority, treatment as state, then you don't have a great grounds upon which to bring a legal case. You don't have the authority that you need to stop that interstate migration of pollution. So that's a powerful thing that tribes have the ability to do, except in Oklahoma. Because in Oklahoma, there was a special law passed called Safety, which said that in Oklahoma, an Oklahoma tribe cannot receive treatment as state unless the state agrees that they are to be permitted that treatment. So essentially, it blocks Oklahoma tribes from being able to access this powerful source of authority. And that's been the case for a while. Now, what they had never done before and what the law permitted them to do was it not only did it prohibit tribes from exercising that jurisdiction, but it contained a provision which said the state can instead seek authority to enforce its standards on Indian country upon its request. And the EPA shall give that authority to the state. Now, the state had access to that authority for a long time, but it wasn't that concerned about receiving it because it was just in their minds tribal trust and restricted lands, just these little dots on the map I talked about before. But in the wake of McGirt, that changed their feelings about it. And Oklahoma requested and received from EPA authority to implement their own state standards, to enforce their state standards on a reservation, which is not something that happens anywhere else in the United States. Takes that power away from EPA to enforce the law and hands it over to the state on Indian country in Oklahoma. So that's what SAFE-T did, and that's what Governor Stitt did in the wake of McGirt.
Yeah.
Thank you for that. Yes, Ambassador.
I think the apparent punitive aspect of this shouldn't be overlooked. I mean, and the governor's request specifically said this was in reaction to McGirt, which is just unfortunate. Back to this whole theme that I've tried to push, that we should all be coming from a place of mutual respect among sovereigns and rolling up our sleeves to figure out how to work together. Unilateral actions are just not helpful. But that 2005 Safety Act, let me just also point out, this isn't something that was deliberated on the Hill in view of the public. This act was an inserted midnight rider in a larger transportation bill in 2005. It was one paragraph out of a transportation bill with, I think, slightly less than 12,000 paragraphs in it. And it was inserted without any public discourse and any public discussion. And so AG Hill is absolutely right. Oklahoma tribes are the only nations that the Safety Act provision applies to. So we were singled out without any congressional debate, without any legislative history, for disparate treatment from all the other nations in Oklahoma. So different nations are at various different stages to consider remedies for this. I do know one nation has brought suit here. Other nations are trying to seek an administrative solution with EPA, but again, you're going to see these whack-a-mole things pop up in terms of the attempted exercises or attempted diminishments of tribal sovereignty. I have no idea what the next one will be, but again, and we'll address them as they come up. We're going to be active at Creek Nation in doing this, but it's just unfortunate when the first order of business isn't just working together.
Well, thank you for that. We only have a few minutes left, and I don't see any more questions in the queue. So what I'd like to do, I promised you each that I'd like to give you each a couple of minutes here at the end to close with any remarks that you might have. And I think, because you're both on the ground and really experiencing all of this in real time, and leading the legal efforts in such a remarkable way. And my heart goes out to you, and my hat goes off to you, and all of those things, because I just think you've done an incredible amount of work and have been such visionaries in the field. And I thank you so much for taking your time to share your experiences, because I know your time is incredibly valuable. So I want to just give you a couple of minutes here at the end to give closing remarks really on anything. I mean, I think I'm really curious where you see things headed, and maybe even aspirationally where you would like to see things headed, and sort of the big picture, the bird's eye view of where we go from here after this incredibly profound decision, and what does Indian country look like moving forward. And I'll start with you, A.G. Hill.
I think that that McGirt, I try to take time out of my day when I'm trying to deal with the various, sort of brush fires that we're dealing with all the time, to appreciate the fact that McGirt has fundamentally rebalanced Oklahoma and the tribes. It has shifted the ground completely and rebalanced that relationship back to what it always should have been, where the tribes have authority over their own reservations, and it is historical, and we are setting the course that will go down as this is what the Cherokee Nation did. This was the reaction that we had to the moment that we faced. And, when these cases come to us and these individual victims who deserve justice come before me, I feel the weight of that, that the government is not something that you write about, it's something that you do. And the obligations of that should weigh heavy on everybody who's involved to make sure that the government that we're putting forward is one that's worthy of the Cherokee people and of the history and the sacrifice that was made so that the reservation would exist, so that we would be here to do this work. And so we take that really seriously. It's not something that these are not intellectual questions, but these are the most fundamental questions about what is it that our citizens demand from us? What is the moment demand from us, and how do we meet it in a way that makes sense, that protects our community and improves the lives of Cherokee people? And I wish that was an academic exercise sometimes, because it's very difficult to weigh the different competing interests and to make the smart decisions that you have to make to ensure the future that you want. But that's the work that we signed up to do. So aspirationally, I like to think about Oklahoma in the future as being a place where everything is a lot different than it is today. And it's in a much better balance, where tribal people and tribal governments are not considered a sideshow. It's not considered anything unique, but it's considered absolutely ordinary. The power of tribal governments, the authority of tribal courts is absolutely something you wouldn't bat an eye over, because of the job that we've done to ensure that this is a permanent and enduring victory for Indian country and for the Cherokee Nation and its people, so that we really have a system that we can be proud of.
Great, thank you for that. Ambassador?
Yes, and I see a couple questions came in. I know we won't have time to address all of them, but I do want to address the economic development one, because the points that I tried to make before and I've made elsewhere about an opportunity for prosperity, those aren't platitudes. Let me explain what I'm talking about. What I'm talking about is being able to clarify who has the authority to engage in public planning. With this kind of herky-jerky, kind of mixed bag of jurisdictional authorities that come from cases such as Oliphant or Montana. It's always been unclear what type of long-term public planning can take place in Creek Nation and elsewhere. Creek Nation does what it has done what it can to provide programs and services, not just for its citizens, but for everybody on our borders. But it's always been difficult when you can't. It's like playing chess with only being able to make every third move. Now, with the clarity that allows for long-term public planning, you can set incentives for businesses to come to Creek Nation. We're already in talks with bringing a number of industries to our nation. And keep in mind, the benefits to non-natives go well beyond tax rolls. We're talking about jobs. We're talking about downstream economic benefits. We're talking about vendor benefits. And, a rising boat, a rising tide lifts all ships. Sorry. So what I'm saying about shared prosperity, these aren't platitudes. If we work hand in hand for long-term public planning, and we'll all be better off. So I just wanted to make that point. Sorry for answering one additional question, but I did want to address that. And in terms of the cultural impacts, there are going to be other benefits to cultural preservation as well. But in terms of closing thoughts, I've spoken quite a bit about my initial reaction when I heard the case, and folks who may have read a thing or two that I put out there probably understand that this was a very profoundly important moment as for the family. But none of that compares to kind of the feeling I know folks who weren't with us in that moment would have had, the emotions folks like my mom or my aunt would have had when this decision came out. As a Creek citizen, you grow up being well aware of the history of your removal to Oklahoma, your survival despite, frankly, a history of deprivation, and you're very aware of the concerted efforts to decimate and obliterate your reservation and your culture. And you have a pride in the fact that your ceremonial grounds exist despite that history. You have a pride that your family lines exist, that you're still here. But that pride has always and is always tempered with a little bit of mistrust about the institutions of the United States in getting things right. And so for the Supreme Court to issue a decision which, as we said before, on narrow legal grounds, wasn't monumental. They simply upheld precedent. But to do so when the stakes were so high, given this backdrop of deprivation, it was profoundly moving. And, I cried, many people cried. We need to protect this decision. We need to beat back the fear mongering, and we need to embrace this moment to build a better future together. And that's how I see McGirt. I know that feeling is shared among Creeks, but also natives throughout this country. And I just really appreciate the opportunity to join you today, Professor Riley. Really appreciate the questions from the students, and just from the bottom of my heart, Mado.
Thank you so much, Ambassador. Unfortunately, we're out of time. A.G. Hill, in fact, got called away, so she said her apologies. But my deep appreciation to you. This was incredible. I always love hearing you speak, and I always love hearing what's happening at the Muscogee Creek Nation, which has been, really an inspiration to so many of us. And your leadership is really deeply valued and remarkable. So thank you. Thank you all, students and audience, for being here. And we hope to cross paths with you in the future. We have more events coming up, so please keep an eye out. We're going to have a panel on the Cooley case, which is going before the Supreme Court, and oral arguments are next month. So keep an eye out for that. Thank you all. Thank you, Ambassador.